Go ahead, Assembly Member.
Thank you, Madam Chair. Did you say Assembly or Senate Judiciary Committee?
I believe I said Senate. I never chaired Assembly Judiciary.
I know.
So
I thought you said Assembly.
Say, but who knows? The record will reflect whatever I said.
Okay.
Go ahead.
Okay, thanks a lot. Madam Chair, California has one of the largest homeless populations in the country. There are roughly 157,000 homeless people living in California, 30% of whom are veterans. Even worse, California is number one in the nation for the highest rate of violence against homeless people. Those who attack the homeless view them as defenseless targets, undeserving of respect and unworthy of mercy. In our state, homeless people have been set on fire, stabbed, shot, and beaten with baseball bats. Their assailants seem convinced that they are less likely to suffer serious legal consequences because their victims are so powerless and vulnerable. AB 312 declares that a homeless person has the same right as anyone else to be free from violence or intimidation. More importantly, it gives them the right to sue their attackers for enhanced civil penalties. AB 312 raises the stakes. It says to the bullies that there may be a high price for these actions, and it does so without adding additional strain to our law enforcement or our correction systems. AB 312 is supported by various advocacy groups, such as AMVETS, California Peace Officers Association, California State Sheriff's Association, and the LA County Sheriff's Association, NAMI California, US Vets, and many others. Today, I'd like to ask for your aye vote, and with me today is Paula Lamazzi, Director of Sacramento Homeless Organizing Committee, and John Kranzitz from Safe Ground, Sacramento.
Thank you very much, and welcome to the witnesses. If you could keep your testimony to as brief as possible, about 3 minutes if you could each, please. Go ahead.
Okay, well, I've come here today to tell you about some of my friends. There's so many of them that have had problems. I'm just going to limit it to one, who's Bernice Nixon. Now, she was sleeping down here by the library, and a man came along and stabbed her in the neck. And when he was asked, why did you do that, he said, because I can. Which just indicated to me that there's just no fear here. That it's like you can kill a homeless person and that's expendable. Now, I myself have been attacked several times with sharpened sticks while I was trying to collect recycle. I've been shot at 3 times. Once with, I'm sure, was a high-powered handgun. I'm not sure of what I was shot at with the rest of the time, but it's pretty clear that these people that were shooting at me were gangbangers, and they're just figure, well, this is an easy way to make my reputation. So the thing that's really scary about that is that these people are just warming up on homeless people. They're using them for target practice. I mean, it's not long if we allow these people to stay on the street. This is a danger to everybody. They're just warming up. They're looking for even worse things coming, and we're just the targets. Right now, we have 2 people that, within the last 6 months, that were murdered, and we're not sure of who killed them, but the way they were killed was so brutal that there was a lot more to it than just trying to rob them. As a matter of fact, one of them had $645 in his pocket when he was found, and yet he was beaten mercilessly with a baseball bat to death. He was one of our long-term residents, and there's just no way that could have happened for robbery. Obviously, he had the money or anything. There had to be rage behind this. It was so brutal, the way it was done. And I really think that we need to send a clear message to our population that this is unacceptable, that homeless people are citizens, and that if you do this to them, if you hurt them badly or kill them, then there will be a price to pay for it. It's not like this is going to be a free pass. And we've seen this too many times. So
thank you. And can I ask you to state your name for the record, please? I neglected.
My name is John Kraintz, spelled K-R-A-I-N-T-Z.
Thank you very much. Yes, go ahead. And start with your name, too, please.
Okay, I'm Paula Lomazzi, Lomazzi, and I'm the Executive Director of Sacramento Homeless Organizing Committee. And through my works, I've heard, since I've been working with Sacramento Homeless Organizing Committee, I've heard many reports from homeless people that have had violence perpetrated against them, like being shot with paintball guns, eggs thrown at them, rocks, and more lethal attacks. But previously, I was also homeless, and one day I was just sitting on the curb next to where I slept in a vehicle, and 3 teenage girls came in and beat me up pretty badly, and they left for a while. They came back and beat me up some more, and it was just because I was there and vulnerable, I guess. I don't know why, but I went to the hospital, and there was I was severely bruised and in pain, but it was no broken bones or anything. But the pain lasted for a couple weeks, but the emotional scar lasted several years, where I was just afraid to walk down the street. It was pretty scary. But I feel lucky to be alive after learning that 1 in 3 violent attacks against homeless people by house people in 2009 resulted in death. This is according to the National Coalition of Homelessness' 2010 report, Hate Crimes Against the Homeless, America's Growing Tide of Violence. In this report, it says, complicating the hate crimes issue and adding to its growth is that young teens are continually being exposed to homeless people being dehumanized in popular media, while cities continue to create policies that criminalize the benign daily activities of homeless individuals. I believe that this legislation would send a strong message to counter that violence against homeless people is unacceptable in our society.
Thank you very much. Before we go into the next witness, we now have a quorum, so we'll take the roll.
Evans?
Here.
Evans here. Harmon? Here. Harmon here. Blakesley? Here. Blakesley here. Corbett? Here. Corbett here. Leno?
All right, great. We have a quorum. Go ahead, next witness in support.
Elena Perez with the California National Organization for Women in support of the bill.
Christian Foy with the City of Long Beach in support of the bill. We want to thank the member for bringing this bill forward. Appreciate it.
All right, thank you very much. Any other witnesses in support of the bill? Witnesses in opposition? Okay, questions or comments from committee members? All right, Ms. Lowenthal, you may close.
Thank you very much. I respectfully ask for your aye vote.
All right, I am ready to entertain a motion. All right, we have a motion. Call the roll, please.
The motion is due. Pass the Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? No. Harmon, no. Blakesley? No. Blakesley, no. Corbett? Corbett, aye.
All right, the vote is 2-2. We'll keep the roll open for Mr. Leno to add on. Next, we have item number 3, AB 433. Again, Assemblymember Lowenthal.
Thank you, Madam Chair. I would like to thank you and the committee staff for your help on this bill. And please note that I will be taking the committee's suggested amendments, which are noted in the analysis. AB 433 simplifies the existing process by which a transgender person obtains appropriate identification documents. Current state law is challenging to navigate, and it conflicts with the medical standard applied by the U.S. State Department. The result is that many transgender people find themselves with a U.S. passport stating one gender and a birth certificate with another. AB 433 would put an end to that. This bill will bring the state's vital statistics law in line with federal standards by streamlining the existing process, making it easier to obtain an updated birth certificate. I respectfully ask for your aye vote.
All right, thank you very much. Witnesses in support. And again, try to limit your testimony to 3 minutes at the most, please.
Sure. Larry Doyle on behalf of the Conference of California Bar Associations. AB 433 would remove unnecessary impediments in the legal processes for obtaining a judgment relating to change of gender and for California citizens, a revised birth certificate reflecting that change. It does this by clarifying that transgender individuals born in other states and now residing in California may obtain a judgment of gender transition in the state, by simplifying the process for obtaining such a judgment, and by making the standard upon which the judgment is based consistent with that used by the federal government. It clarifies that persons born in California but now residing outside of the state may obtain a revised birth certificate reflecting now appropriate gender, removes similar unnecessary impediments as described fully and well in the committee analysis. It's a good bill. It removes unnecessary legal impediments, and we ask for an aye vote.
Thank you. Next witness.
Good afternoon, Chair and members of the committee. My name is Christina Wirtz. I'm the legal director of the Transgender Law Center here in California. At the Transgender Law Center, we get about 1,500 calls from transgender people seeking legal help every year. And far and away, the highest volume of calls comes from folks who are trying to navigate the complicated process of obtaining a new birth certificate to reflect who they truly are. For transgender people, recognition of their gender identity is a matter of basic human dignity. And in order to live as their authentic selves in a safe and stable way, transgender people need identification that's consistent with who they truly are. Because of this, California's long had a law for about 34 years, in fact, that allows transgender people to one, obtain a birth certificate that reflects who they truly are, and two, get a court order recognizing their change of gender. Unfortunately, this law creates numerous procedural barriers and is difficult to navigate. AB 433 would alleviate the confusion, anxiety, and even danger that transgender people face in trying to get identity documents that accurately reflect who they are. This bill would streamline current law and clarify that eligible petitioners, either living or born in the state of California, can submit a gender change petition in our courts. Neither of these are changes in the law. They're simply a matter of making the process available to those who need it. This bill would allow people who were born in or who live in California to use a simplified process that requires medical certification that someone has undergone clinically appropriate treatment for gender transition in order to obtain a new birth certificate. This change conforms California standards to the standards set forth by the U.S. Department of State for changes in a passport. And the bill also contains a model declaration that makes the process that much simpler for folks to navigate. Transgender people, like all of us, deserve to live with dignity and respect. Something as simple as government recognition of our gender identity goes a long way, and AB 433 is a simple and cost-neutral way to make sure that happens. We requestfully respect your...
Respectfully,
you know what I'm saying.
Thank you.
Thank you, Senator Lynn.
Thanks for your testimony. Yes, sir.
Good afternoon, Madam Chair. Mario Guerrero with Equality California. Would like to thank the author for this great piece of legislation and request your support for the bill. Thank you.
Elena Perez with the California National Organization for Women in strong support of the bill.
Okay, any other witnesses in support?
Hi, Sabrina Means on behalf of the California Faculty Association, which represents faculty at the California State University System, in support.
Thank you. Any other witnesses in support? Witnesses in opposition? And again, if you could keep your testimony to 3 minutes or less, I'd appreciate it. And start out with your name.
My name is Michael McDermott, McDermott. I am an advocate on behalf of the civil rights of this nation's despised and disposable male minority and a graduate in the George School of Law. I'm here to oppose AB 433, the Rocky Horror Thought Crime Law. AB 433 is part of an ongoing campaign of anti-scientific thought policing and ideological bullying in service of promoting a political agenda of misandry, the hatred of men, masculinity, and normal heterosexuality, and supporting related separatist exterminationist programs against the male gender, a true Rocky Horror nightmare. The main purpose of such laws is to literally destroy gender, and particularly male gender, as a legal concept. Hence, this bill is essentially a bait-and-switch scam. They pretend it's about people's birth certificates, but in fact, it's about forcing the rest of the citizens of this state to pander to these outrageous anti-scientific lies. When people are forced to remain silent when they are being told the most obvious lies, or even worse, when they are forced to repeat the lies themselves, they lose once and for all their sense of probity. To assent to obvious lies is to cooperate with evil, and in some small way to become evil oneself. One standing to resist anything is thus eroded and even destroyed. A society of emasculated liars is easy to control. Through using the judicial contempt power, they will be able to use thought crime laws to actually send people to prison who refuse to deny their own gender.
Of the bill?
Pardon me?
Could you talk about the bill itself?
Well, the bill is essentially requiring me as a male. I was born a male. I inherited my male gender at the moment of conception when life began. This bill says I cannot assert that in a court of law without being sent to jail for political thought crime, failure to pander to this law which says that my gender must be a perception. It's a zero-sum game. Either gender is a perception or it's inherited at conception. You can't have it both ways. Our textbooks nowadays say you need a mother XX and a father XY to have a child. Our laws say you can have two moms or two dads and still produce a child. It's scientifically insane, and that's what this is about, to promote Orwellian doublethink as a means of promoting political pandering to the hatreds and perversions of the radical gender feminist, homosexualist misandry machine. I hope this council will take the time to tell and inform the people of this state what the punishment will be for failure to lie about the gender of someone who claims it's just a perception. Because the pervasive, endemic misandry that characterizes a legislature controlled by Democrat misandrists means that this is truly a body unfit to pass gas.
Thank you very much for your testimony. Any other opposition to the bill? Questions or comments from the committee members? Mr. Leno?
Thank you. I want to speak in support of Assemblywoman Lowenthal's bill. It's not huge in effect for the greater population, but it's very important to a population that suffers greatly. I got involved with transgender civil rights issue as a member of the San Francisco County Board of Supervisors, and when coming to learn that upwards of 70% of the transgender community is unemployed, has very difficult access to housing, to employment, to health care, to education, I began working on these issues. Keep in mind that state law already prohibits discrimination based on gender and gender identity in employment and in housing. And that the way the bill is written very narrowly, that the bill only applies to an individual who's already undergone some clinically appropriate treatment for purposes of gender transition. So by definition, this would be an individual who has been deemed to have a gender dysphoria, which is a clinical diagnosis. And there are a variety of different proposed treatments for it. It can be psychological treatment, it can be hormonal treatment, it can include surgery, not necessarily. So this is someone who has been diagnosed with gender dysphoria. We know that they're already disproportionately underemployed and with difficulties of accessing housing and education and health care as well. This just removes one small hurdle that they're already dealing with, and so I think it's the least that we can do so these individuals with a diagnosis who have been treated, who are trying to move on with their lives, can do so with one less obstruction. I think it's completely supportable, and I would ask my colleagues to join me, and I make the motion to move the bill.
All right, we have a motion, and I wanted to just clarify something that a question that I had when the bill first came to my attention regarding the new birth certificate, because the maintenance of public records is very important, that we don't change the original birth certificate. So my understanding is the original birth certificate does not change; it remains on file, but a new one is issued to the individual so that they can be consistent with passports and driver's licenses and things like that.
Yes, a new birth certificate is issued to the individual, and that's actually the current process under the Health and Safety Code currently as well. It doesn't change that.
Yeah. Okay. Great. Yes, Mr. Harmon.
Well, I think the chairperson has asked the right question, but I don't think it was answered. Do the original public record that's on file, that's used by statisticians and demographers and so forth, does that stay, or is that changed also along with the new birth certificate that's issued?
My understanding is that a new birth certificate is issued. I'm actually not 100% sure about the original birth certificate. I do know that there's no public access to that record.
My understanding is the original birth certificate remains the original birth certificate, and that the statistics do not change.
Okay, good. That's the way I...
Right, because I as a, somebody interested in history, I want to make sure that the historical record isn't changed, but the individual obtains the record necessary to be consistent with other records. Okay, so we have a motion. You can call the roll.
The motion is due pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Harmon, no. Blakesley? Blakesley, aye. Corbett? Corbett, aye. Leno? Leno, aye.
All right, 4-1, the bill is out. Thank you.
Thank you.
Next, we have Mr. Silva. We have two bills, starting with item number 4, AB 454. Go ahead, Mr. Silva.
Good morning.
Hi.
Good afternoon.
Afternoon.
Madam Chair and committee members, first I'd like to thank the committee staff for suggesting the amendments that were taken on May 27th regarding the timing of the notice. AB 454 is intended to ensure that persons protected by restraining orders receive actual notice of any special hearing set to terminate or modify that order. AB 454 requires a party seeking to terminate, shorten the duration, or otherwise modify a non-criminal protective order to provide the actual notice to every person protected by the order by personal service or in accordance with the Safe at Home program. If the party who is protected by the order cannot be notified prior to the hearing of AB 454 requires the court to deny the motion to modify or terminate the order without prejudice or to continue the hearing until the party who is protected can be properly notified. There is no known opposition to this bill. Here with me today is Mr. Larry Doyle, representing the sponsors of the bill, the Conference of California Bar Association.
Good afternoon, Madam Chair and members. Again, just to identify, Larry Doyle on behalf of the Conference of California Bar Associations. This is a fairly simple bill, notwithstanding its length. Protective orders are issued for the benefit, for the protection of the protected party. AB 454 is designed to ensure that whenever there is a hearing to terminate or modify a protective order, before its natural expiration date, that the protected party will receive notice of that hearing. The bill started off as simply dealing with domestic violence protective orders, and we received some very good advice during the course of the process, beginning with the idea that we needed to make this consistent with the other civil protective orders within the various code sections, and to make the other changes culminating in the recommendation of this committee that we make the notice provisions consistent. There is no opposition, as Assemblymember Silva has said. There's a lot of support, and we think it's a good bill and urge your aye vote.
Great. I think we're ready to hear from the support.
Elena Perez with the California National Organization for Women in strong support of the bill.
Beth McGovern with the California Commission on the Status of Women, also in strong support. We heard about this issue at one of our public hearings where someone came and told us about this problem and recommended that the law be changed to do exactly what this bill does. So we very much support. Thank you.
Great. Any other witnesses in support? Witnesses in opposition? I have to say, when this bill came to my attention, I thought, this isn't already the law? Right. I mean, it just seems like a no-brainer. It should have been the law all along. Comments? Ms. Corbett?
Chair, I'm ready to move the bill if you're ready.
All right, we have a motion. Any other questions or comments? All right, we'll call the roll.
The motion is due. Pass to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Aye. Harmon, aye. Blakesley? Blakesley, aye. Corbett? Corbett, aye. Leno? Leno, aye.
That bill is out with 5 ayes.
Thank you. Thank you.
Madam
All right.
Chair, while Assemblymember Silva is here, I believe he has an item on consent. I'd like to move the consent calendar.
Great. We have a motion on the consent calendar. Call the roll.
Evans?
Aye.
Evans, aye. Harmon? Harmon, aye. Blakesley? Blakesley, aye. Corbett? Corbett, aye. Leno? Leno, aye.
Great. Consent calendar is out with 5 ayes. You are on a roll, Mr. Silva.
Boy, let's go.
Would you like to go for 3?
Let's go for 3.
Item number 8, AB 1333. Go right ahead.
Thank you, Madam Chair. AB 1333 addresses the perception of a possible conflict of interest for persons serving on the grand jury. The core function of the grand jury are to act as public watchdogs. They weigh criminal charges and allegations of misconduct against public officials and determine whether indictments should be returned. It is important that the public trust their decisions. AB 1133 simply prohibits a juror from investigating an agency where that juror is currently employed or where he or she has recently been employed. Currently, grand juries have the discretion of setting their own policies, and my bill does not try to alter that authority, but it would like to set up rules that we would see the grand jury have to follow to protect innocent parties.
So the committee has suggested some amendments to your bill, which we have in mock-up form before us. Are you accepting those amendments? Yes. Okay, great. All right. Witnesses in support?
Okay, well, with me here today...
Oh, sorry. I thought you were ready for witnesses.
Okay. This measure is sponsored by the County of Orange, and it has no known opposition. With me today is Ann Fletcher from the Orange County Council's office.
Good afternoon, Madam Chair and committee members. My name is Ann Fletcher with the Orange County Council's office. I'll scoot up. That better, hopefully. There we go. Thank you. Part of my function with the County Council's office is to provide training and advice to public officials regarding conflicts of interest. And so I'm very closely interested in following this piece of legislation. By way of background, this legislation will just address the civil function of the grand jury, not the criminal function. In its civil function, the grand jury prepares reports and conducts investigations. And we had a situation that arose within the last year in Orange County where there was a grand juror who was a former county employee who was involved in an investigation of a related county department. And that created the perception that there was bias in the investigation. So this bill, I believe, would address that situation. I have another example, too, but in the interest of time, I don't think I'll go into that unless the committee would like me to. In terms of what legal remedies are available currently under the law, there is nothing, no statute in the law as it currently exists that addresses non-financial conflicts of interest for the grand jury. There is the Political Reform Act, which the committee members may be aware of, which pertains to disqualification of public officials in making decisions where there are financial interests in that decision. That wouldn't probably apply here because there's an exception for salary from a government entity. So if a grand juror previously worked with a public entity, that exception would apply, and the Political Reform Act would not govern. There's also a provision of the law that allows a grand jury to enact its own rules of procedure, but it does not require, as written at this point, for the grand jury to include conflicts of interest. So this legislation would address that issue as well. Whether a claim of grand juror conflict of interest or bias is founded or unfounded, it detracts from the goal of the grand jury as a neutral, unbiased arm of the judiciary. The addition of this penal code section would help alleviate that concern by requiring a grand jury to disclose employment within the last 3 years with an agency within the civil grand jury's jurisdiction and to recuse himself or herself from participating in an investigation of that agency. I'd be happy to answer any questions the committee may have.
Great. Thank you very much. Any other witnesses in support of the bill? Any witnesses in opposition? Questions or comments from the committee? Mr. Blakesley?
Sounds like a reasonably sort of good idea. The only thought that entered my mind is if it's a sufficiently large agency, might it be that the person's participation would be helpful by virtue of their understanding of the complexities of the organization? I'm thinking about if you're investing a sheriff's department and there happens to be someone who, had been a deputy sheriff, maybe a good person to have present just by virtue of their insights. Again, not trying to really contest the purpose, but just wondering if this blanket prohibition or a blanket approach may inadvertently catch up those who you might want to be present.
I think that is a valid consideration. That is certainly something to weigh, the experience that the grand juror brings to the grand jury. I think the legislation addresses that by having a 3-year bar. So in other words, if it's someone who has been employed with beyond 3 years, then there isn't a problem, but it's just within the immediately prior 3 years. And it's to address a situation where there really is a potential for the appearance anyway of a bias.
Mr. Harmon?
A couple of questions for the witness, if I could. It sounds like you are a little bit expert in this, but there's nothing in the bill that indicates the time that the disclosure has to be made to the foreperson or the court that there's this potential conflict. So when does a grand juror have to tell the court, gee, guess what? I'm employed by XYZ agency. That's the first question. It seems to me there ought to be some specific point in time in the proceedings that that disclosure should be made. And then the other one that sort of made me wonder is they have to disclose if they work for an agency that is within the investigative jurisdiction of the grand jury. And I'm concerned that a grand juror, who are generally laypersons, not particularly familiar with county government or state government or wherever, how do they know what's within the investigative jurisdiction of the grand jury?
All right,
should we define that?
If I may respond, with regard to your second question, the Penal Code is very specific about what the investigative jurisdiction of a grand jury is. I can answer for Orange County. I know that very detailed training is provided to the grand jurors at the beginning of their term, so they're trained on what their jurisdiction is and advised about what they have jurisdiction over and what they don't.
Well, let's say that just a hypo, a grand juror is or had been an employee of some obscure small water district or something like that. Are all the water districts in Orange County going to be listed in every little public agency that's within the area of investigation of the grand jury? I'm just concerned someone will come in there and have a duty to disclose, and they won't realize that they have a duty to disclose because they don't know that that agency or whatever it was they worked for is in the disclosure category.
That's something that could be added to training very easily.
Might want to take a look at it. And the timing, too.
Would you like me to respond to your first question?
Oh, yeah, you didn't do that, did you?
Right. With regard to the first question, you're right, it's not in the legislation, and it seems to me it would make sense to have that disclosure made to the court at the beginning of the process, either at the application process.
But the bill doesn't say that. I'm worried the disclosure might come after the fact, that the grand juror says, oh, by the way, I work for this water department or this county agency or retired from them or something like that. And what about consulting? Oftentimes these agencies hire consultants. This bill only talks about employment or retirement. What about putting something in about consultants that are oftentimes hired by agencies, and then that consultant winds up being on the grand jury? That might be something you want to think about. Thank you very much.
I think these are all things worthy of consideration for possibly future legislation, but as I read the bill, and it's very simple, it deals with current employees only, not former employees and not consultants. And it's obvious that there is a conflict of interest for the employee.
Excuse me, Madam Chair, but my copy of the bill clearly says former employees.
Oh, I'm sorry.
Current and former.
Right, it's up to 3 years.
Okay.
But the obvious conflict is in the investigation by the employee or the immediately past employee of their own agency. I mean, that's clearly a conflict of interest. So it is very limited in scope. You're right. But this is another one of those bills that I looked at and I thought, well, duh. This should have been the law all along. And I would imagine that most grand jurors, being responsible people that are trying to discharge their public duties, would bring any potential conflict of interest to the attention of the court. Nonetheless, I think it's a good bill and limited in scope. But you've raised some
I would move approval of the bill.
All right, we have a motion. Call the roll.
The motion is due pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Harmon, aye. Blakesley? Blakesley, aye. Corbett? Corbett, aye. Leno? Leno, aye.
All right, the bill is out 5-0. You did 3 in a row.
Thank you.
Good job. Thank you. All right. Our next bill is AB 1305, Assemblymember Huber, item number 9 on our agenda. Go right ahead, Ms. Huber.
Good afternoon. Thank you, Madam Chair. AB 1305 raises the probate code threshold for disposition of a descendant's estate without the need for formal probate administration. Raising the threshold will reconcile limits with increased values due to inflation and reduce the burdens on the judicial system. We haven't raised the limits on these items for 15 years, and as such, many small estates that would have qualified to use the small estate provisions as enacted no longer qualify to use these procedures. I could go into the details, but I'm sure you're all well briefed on the details of the different probate code provisions. But the bill is sponsored by the Trust and Estate section of the State Bar, and I do have a witness here on behalf of the Bar section to testify.
And there is no opposition. All right, go ahead with your witnesses.
I'm Gina Lara on behalf, as was noted, on behalf of the Trust and Estates Executive Committee of the State Bar. I'm a practitioner in this area and have been for 15 years. One of the charges of our executive committee is to periodically review probate code sections for technical updates. And as noted, this provision for the thresholds for when a formal probate would be required and various other dollar threshold amounts has not been updated for about 15 years, and even before that it hadn't been updated for a very long time. So this is really playing catch up in a significant way to bring these threshold figures more in line with the dollar values that we see today, even in modest estates. Many estates that would otherwise should really not be subject to probate because they are so modest are going through the process, creating a huge burden on the courts, as well as costing families and the estates of these decedents unnecessary costs of administration and burden in administering their loved ones' estates. So we support the provision as it stands.
Great. Any other witnesses in support of the bill? Witnesses in opposition? Comments or questions? Mr. Leno has moved the bill. Did you have a question, Mr. Blakesley?
Seems like a reasonable bill, and obviously families go through very difficult times in the aftermath of a loss in the family, and the difficulties and costs of probate are well known and documented. How was this $150,000 number selected as opposed to $200,000 or perhaps even a larger figure? Is it a simple CPI adjustment? Is it trying to ascertain, what percentage of the cases that potentially would qualify really shouldn't be in the courts? Could you help educate me a little bit on that?
Go ahead. Okay. It's my understanding that initially the bill was presented with higher dollar amounts, and then adjustments were made to those to bring them more in line with the concerns that had been expressed by stakeholders. I think it was designed to be adjusted for inflation. I have to tell you, I don't know, and maybe you might speak on this issue, whether there was an actual mathematical calculation that was done for the relative to the CPI index. I don't know that was undertaken. I think we were looking at reasonable limitations to mirror inflation. But whether an actual mathematical calculation was done, I'm unaware of that level of detail, and I apologize to the committee for not being aware of that.
It's in the analysis. It is.
Yeah, it was
CPI.
the committee. The committee did request an adjustment of the dollar amount to mirror inflation, and that's where it came back down to 150. It was originally 200,000.
Thank you. I'll be supporting the bill. I think I probably would have supported it at a higher level because of, again, challenges families have at that critical time and the amount of work that's already being put upon the courts.
Always of concern. Okay, do we have a motion? Yes. Oh, Mr. Leno moved the bill. Call the roll.
The motion is due pass to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Aye. Harmon, aye. Blakesley? Blakesley, aye. Corbett? Corbett, aye. Leno? Aye. Leno, aye.
The bill is out with 5 ayes.
Great.
Thank you. All right, we have one bill on call, members. We'll lift the call on item number 1.
Leno? Aye. Leno, aye.
That bill is out 3-2. All right, that wraps up the committee's business for today. In record time. And with a record number of unanimous votes. All right, good job, everybody. We're adjourned.